the court concluded that it was perfectly reasonable for Janet Nguyen to request and utilize that voting process, and therefore the court did what it was supposed to do. It did a full and complete inquiry. Quite candidly, Your Honor, if the court has no further questions, that was the sole issue. I'm not going to take up any more court's time. I would just point out that the statutory scheme, the law basically provides that unless there's complete proof of fraud or illegality in an election, the courts are obligated to sustain the finding in the trial court in terms of an election contest, and we would ask that the court do so at this time.
Thank you, County Counsel.
May it please the court, Leon Page, Deputy County Counsel, appearing for the Orange County Registrar of Voters.
Before you get started, can you also address Mr. Schroeder's comment that how he resolves the schematic problem of both?
Absolutely.
It's a good start.
If Mr. Schroeder's interpretation was accurate, that both did not mean a combination, that would suggest that you would have to do two separate recounts. You would have to do an electronic recount and then a manual recount. Now the question would be, what would be the purpose of doing that purely electronic recount with the vote? As we said in actually our brief to the trial court, it would be an informational, non-binding recount that would serve only to spread uncertainty as to the election. So 15627 doesn't speak of multiple recounts. It speaks of one. And the voter has a choice. It can be manually using the voting system used originally, or both. And when the voter chooses to conduct a manual recount, they then have yet another choice. They can choose between relying on paper record copies or on the VVPAT. So not only does Mr. Schroeder's interpretation not survive because there's only one recount that is ever specified in 15627, but consider that 15627 would allow a voter to request, if they wanted, to solely use the voting system used originally, which for the most part would have been an electronic vote. And if that's the interpretation, how can you possibly square that with their interpretation of Section 19253, where they read that to mean that the VVPAT is required in every election? It just can't survive. So Judge Brenner did something entirely appropriate. He reconciled these two statutes in a way that gives meaning and effect to both. It doesn't read 19253 in a way that eviscerates 15627. But I think it's important for the court to remember that this was a voter-requested recount. And when you read the statutes in that section of the Elections Code, time and time again, the legislature has given the choice to the voter. The voter requesting the recount, the voter paying for the recount is in the driver's seat. And we as a government agency, that's perfectly appropriate.